Kumarasamy.
It's ready.
My Lords, may it please your Lordships, I appear on behalf of the appellant with my learned friends Mr Gunn Cunningham and Mr Brayley. My learned friends Mr Benson and Mr Armstrong appear for the respondent. My Lords, dealing first of all with the case documents, there are two additional notes. There's one from my side which was served at the end of last week when I came into the case. And there's a very recent addition by from the respondents.
For my part, I'd seen yours, but I hadn't seen the respondents' additional note. I don't know whether others had.
No.
Would it be fairer for us to read it? Mr Benson, would you like us to?
My Lord, firstly, I apologise for the late
arrival
of that document. It is confined to an answer to the appellant's recent note. We intended to deal with the matters in oral argument, but thought it would assist the court if there was a note.
Would you like us to read it now, or are you happy to wait?
I'm happy to wait.
Fine. That's fine.
Thank you.
Thank you very much. You have nothing to apologise for. The appellants produce something late. For you to produce something later is perfectly understandable.
Thank you very much.
Yes, Mr Rainey.
My Lord, thank you. I think the only other point which I perhaps ought to mention is the agreed timetabling. I think we agreed that we'd have an hour and a half each with half an hour for reply, which would, it seems to me, lead to a slightly earlier finish than necessary. In your Lordship's hands, but I wonder whether if I hadn't quite finished developing my arguments by 12 o'clock as to whether your Lordships might indulge me with another few minutes.
I think we probably would, but let's wait and see.
Thank you, my Lord. My Lord, if I can start with the Act itself very briefly.
Yes.
And then
incidentally, apart from the respondent's additional note, which we quite understand why it's produced late, we read the judgments below and the written cases and your additional note. But certainly,
I'm very grateful, my Lord.
We should look at section 11. Yes.
Yes. I don't think there'll be any additional documents to look at, save probably a brief look at the leases and the assured short-hold tenancy. But other than that, it really turns on the law and the judgments.
Yes.
It's the text, joint text bundle at tab 4 is where the amended section 11 appears.
Thank you.
Beginning on page 484. Section 11.1 is the section which has the longest antecedents, deriving as it does from the Housing Act and indeed earlier Act.
Yep.
And, I think it's accepted and it's common ground that the way this works is a statutory implied term.
Yes.
So, as it's been put in some of the earlier cases, one simply reads the contract as if it had this term in it, and it doesn't matter that it comes by statute rather than having been written in by the parties. The reason why we now have a case about the amendment is because section 11.1 was an implied covenant to keep in repair at A the structure and exterior of the dwelling house,
yes,
including drains, gutters and external pipes and so forth, and that works reasonably well if it is a house, literally, but it doesn't work so well if it's a flat in a multi-occupied building. So, as we say, probably belatedly to reverse the Court of Appeal's decision in the Campden Hill case, the Act was amended, and so we now have the new subsections 1A, 1B and 3A.
Yes.
Subsection 1A works by, in fact, amending the way the original implied covenant works. And what it says in subsection A is that the reference in 11.1 to the dwelling house includes reference to any part of the building in which the lessor has an estate or interest.
Yes.
And then there's a similar extension for the common services, which is extended in two ways, which are slightly different. One is if they're actually owned by the lessor or under his control, which is leg 2. But Roman 1 is if they're found in a part of the building, or well, if they form part of a part in which the lessor has an estate or interest.
Yep.
1B limits the effect of the covenant in the sense that it says that nothing in subsection 1 capital A shall be construed as requiring the lessor to carry out any works or repairs unless the disrepair or failure to maintain in working order is such as to affect the lessor's enjoyment of the dwelling house or any common parts. And then we have subsection 3 capital A. In the end, I don't submit that it actually makes any difference to the results, but subsection 3 capital A works differently, I would submit. Subsection 3A is a statutory defence rather than working as an implication into the contract. And that comes from...
The closing words.
Yes, in any proceedings relating to. So I would submit that that is in effect a statutory defence, but it must be relevant to the construction arguments to note that this defence is there in the background.
Yep.
And the intention of the defence is, I would say broadly, to absolve the landlord of liability if they don't, in fact, have the right to carry out the necessary works or repairs. And that's particularly relevant to the multi-occupied building situation, which of course is what led to the amendments in 1 capital A. And the way this subsection works is in the final 3 lines. It says, it shall be a defence for the lessor to prove, so the burden's on him, to prove that he used all reasonable endeavours to obtain, but was unable to obtain such rights as would be adequate to enable him to carry out the works or repairs. Yeah. And diverting for a moment into one of the points which I'm going to elaborate, in my submission, Lord Justice Lewison was completely wrong in the way he treated this. It's, I would say, obvious from the way this subsection is drafted that it presupposes that the landlord has had notice. It doesn't make any sense otherwise, because if you haven't had notice, how can you use reasonable endeavours? Or perhaps a more specious but probably equally good point is, well, if you don't know about something, then there are no reasonable endeavours to take. So, in effect, one could say, well, I did everything which was reasonable because I had no idea. But my submission...
But having, it could be said more broadly, can't it, that having a right to repair begs the question about whether you've got notice of disrepair.
Well, in most cases it would, because I also say, as your lordships know, that Lord Justice Lewison was with respect wrong when he said that there is a blanket right to enter into any area which is the subject of a right of way, which is the case here, and repair it.
Yeah. Anyway, maybe jumping ahead, sorry. Yep. Anyway, that's what you say about 3A for the moment.
Yes.
Right.
So that's the...
that's the section in the end where, as it were, construing or deciding the effect of.
Yes.
Yep.
So, my lord, the 3 difficult areas and which are the subject of effectively the 3 arguments on appeal, because the 4th point, what's called the enjoyment issue, is really a subspecies of the 3rd. It's the question about, first of all, what is the necessary estate or interest, which is referred to in subsection 1 capital A.
Yeah.
The second is what is the exterior.
Yep.
And the reason that's important is because it's not the exterior of the building, it's the exterior of the part in which the lessor has the estate or interest. And then the 3rd point, of course, is whether or not there is an implied requirement that the tenant gives his landlord notice.
Is it a requirement that the tenant gives notice or the landlord has notice?
You're quite right, my lord, to pick me up on that. There are authorities which say that if the landlord in fact knew, and it could be proven, then it would not be necessary to prove that the tenant had served him formally. So if I can take the first point, which is the easement issue, and
yes,
pick up on the arguments in the case. In my submission, this turns on effectively the construction of the implied term and not on what one might call the landlord point about an easement. I mean, I, of course, accept that a leasehold easement is a legal easement, and I also accept that, as defined in the Law of Property Act 1925, a legal easement takes effect as an interest in land.
You accept that it's an interest in land, and I think Mr. Benson accepts it's not a legal estate.
Exactly.
Yep. Okay.
So it's definitely not within the word estate. The question is whether it's in the word interest.
Yes.
And I say that the fact that he can quite rightly point to the Law of Property Act doesn't answer the question as to whether it is a sufficient interest for the purposes of Section 11. Because Section 11 has to be read in its context, which is the repair of flats which are let on short-term tenancies, and one has to bear in mind that when construing the section. And although the point doesn't appear to have been directly argued, I do submit that it has in effect come up twice in the Court of Appeal, and on both occasions the Court of Appeal has proceeded on the basis that a right-of-way or an easement is not a sufficient interest to trigger Section 11.
Right.
The first of the case that I would like to take your lordships to is tab 20, which is the Niazi Services case.
Yes.
Decided in the Court of Appeal in 2004. And if I can take your lordships to the head note to set out the very brief bones of the facts. The claimant landlord held a long lease of a top floor flat. So it is like this case. It's an intermediate lessee who's sublet the flat, and the claimant obtains a judgment for arrears, but then the tenant counterclaims for damages for breach of the implied repairing covenant, and no doubt in order to raise a set-off. And certainly the decision of the Court of Appeal, and as it appeared to the writer of the head note between letters G and H, 3 lines down from the letter G, since the landlord had no estate or interest in any part of the building except the top floor flat. For the reasons I'll develop in my submission, that's the right reading of how this case proceeded. The real problem in this case, from the tenant's point of view, was a lack of water supply, and without going into too much detail in respect of the fact, it appears that there was an amendment to the pipes when they created a restaurant lower down the building, and the restaurant was drawing off too much water, which caused a problem for the tenant. And there were, I think, 33 months with reduced water supply, etc. The passages which I submit are important begin on page 883 of the bundle.
Good. Yep.
Perhaps I should, in fact, have picked it up at paragraph 11 at the bottom of the previous page, where Lord Justice Jacob says that the landlord's covenant extends also to an installation which directly or indirectly serves the dwelling house, provided that the installation satisfies one or other of the conditions specified in 11.1 capital A. And then he immediately, at the top of the page, begins to draw the distinctions between head landlords and intermediate landlords. The second of those, owned or controlled by the lessor, will cover, so far as we can see, all cases where the landlord owns the building and the tenant has a direct tenancy from him. If here Mr. Vanderloo had had a direct tenancy from the owner, there would have been an implied covenant. But Mr. Vanderloo was a subtenant. His landlord, Niazi, neither owns nor controls the relevant part.
Excuse me, so hold on a second. Could you shut that door, please? Thank you. Sorry, yes, carry on.
His landlord neither owns nor controls the relevant part of the pipework. Mr. Vanderloo, to succeed, he must show the installation forms part of any part of a building in which the lessor has an estate or interest. These words are not easy. The contest was over their meaning. What is meant by estate or interest, and in what must it subsist? So the estate or interest point was being argued in front of the court. Unfortunately, it's the volume 1 of the weekly law report, so we can't look at counsel's argument, but it's clear that it was being argued. Paragraph 13 is actually important because there's a reference here as to what Woodfall said at the time. I haven't produced what Woodfall says now because it's been rewritten since the Court of Appeal decision in this case. So the important thing is what it used to say.
The editor.
Being Sir Kim Lewison, as I understand it, indeed.
But at this time it was Kim Lewison.
Then and now.
Yes, then and now. But perhaps unsurprising that it's been rewritten to take account of the Court of Appeal's decision. But what it used
You're
to...
hoping it'll be rewritten again?
I am. That is my aim, certainly, my lord. What it used to say is that the landlord's liability to keep the structure and exterior of the dwelling house itself in repair is not dependent on his ownership of structure, but his liability to keep other parts of the building in repair is. Thus, if the structure of a block is owned by a management company rather than by the landlord, the extended obligation will not apply. So that's the reference to 1A. So Woodfall appeared at that stage to support the proposition that in the intermediate landlord situation of a flat, one wouldn't be caught. Although, to be fair, there was a contrary passage in another book.
Yes.
And then paragraphs 14 and 15, Lord Justice Jacob sets out a number of the competing meanings.
Yeah.
And at paragraph 15, he rejects meaning 1, which was a vague meaning about commercial interest. And he says there must be some sort of legally recognised right. Meanings 2 and 3. And then meaning 2, he says, would absolve Niazi from liability because the defects of the plumbing and electricity supply are in parts of the building outside flat 2 and hence not in a part of the building in which it has an interest. Meaning 3 would make Niazi liable because it has an interest in the pipework and electricity by way of a covenant from the head landlord or easement or both. So easements, again, in play, although they hadn't seen the head lease, but no doubt they were right. It was meaning 2, which was then advanced at paragraph 16. And then...
So he's treating there the easement over the plumbing, the pipework as an interest. Or that's one of his possible meanings.
That is one of the possible meanings, but the way the case then develops is that he, in effect, rejects that argument because at paragraph 20, further down the page at 884, he says the critical question is not whether Niazi has an estate or interest in the building of which the defective section of the installation forms part, but whether it has an estate or interest in that part of the building of which it forms part, which is obviously right. It's only this construction, paragraph 21, only this construction which gives any meaning to the words any part of. And then over the page, top of 885, despite the previous references to easements, Lord Justice Jacob says, in the present case, Niazi has no estate or interest in any part of the building except the top floor flat. Thus, if Mr. Van der Loo suffered damage as a result of some structural disrepair in the lower part of the building, he'd have no redress against Niazi under the statute.
But I mean, that can't be literally true because he's already accepted that he has an interest for certain purposes in the pipework.
Well, what he appears to find is that, the way I would put it, is he's effectively making, supporting the submission which I'm making, which is that for the purposes of the Act, simply having an easement isn't sufficient interest.
Well, it's slightly difficult, isn't it? There's a right to receive water.
Yes.
There's not a right to do anything in respect of the pipes. Whereas a right of way over land is a right to do something on that land. Whereas a right to receive water through a pipe is a slightly different concept.
Yes.
They're both easements, of course.
And they do share certain characteristics in the sense that if there is a right to receive water through a pipe, then one can get into arguments that there may be an implied right to, if the supply is interrupted, there may be an implied right to go on to the servient tenement in order to restore the supply. So one does get to the same...
But I mean, if the landlord was to replace the water system with different pipes coming in a different direction and different tanks, that would normally be something he's entitled to do, whereas if the landlord tried to reform the common parts and give you a right of way over a different bit of the building, that wouldn't be something he could do. I mean, you do have a right over land if you've got a right of way, whereas you don't have quite the same right over any particular piece of property in relation to the receipt of water, do you?
There is that distinction, although in the respect of blocks of flats, it's not quite as clear because it's not... with a freehold right-of-way, one usually says, well, here's a deed, and you have a right-of-way between points A and B marked on the plan. It's very clearly defined and quite often a width. Whereas the form of easement one gets in blocks of flats, and it is the case here, is you get a general right over such of the common parts as you need to obtain access to the flats. So I wouldn't, in fact, accept the proposition that it is impossible for the landlord simply to change some of the common parts, so to go by a different route. There is an argument about, or there was an argument about that in a case called Barry House, which was heading for the Court of Appeal, or is still heading for the Court of Appeal, where that argument was taken.
I suppose you say in the end it would depend on the proper interpretation of the particular lease.
Yes, but as a broad, but I do say that.
But I can see how you could draft it so that you'd say the common parts would mean the common parts for the time being, or whatever.
Well, they tend to follow a form. They do tend to be quite vaguely drafted, which just gives the tenant quite wide rights, and one can see a fairly common form in this case in the schedule of rights at Part 2 of my client's lease, which we can look at in due course.
The answer to my point is actually paragraph 17, where he says one's not simply concerned with an interest in the installations. He distinguishes between the installations and a part of the building. I think that's it.
Yes.
Yes.
That's it.
But I was also going to submit that paragraph 22 is important because Lord Justice Jacob there recognises, I would say correctly, that there is a different effect of the implied term depending whether one is dealing with a head landlord or an intermediate landlord who has an interest only in part of the building.
Yeah.
Because he says, at line 4, he says, this is inherent in the statutory scheme. It's clear that such a mismatch may arise in relation to the covenant under section 11(1)AA. And then he says, thus, if the freeholder X grants a lease of the flat on the top floor of the building to Y, and damage is caused to the flat by disrepair of part of the building which has not been included, say the roof, then Y is able to claim damages for breach of the covenant implied by section 11(1)AA. But if Y sublet the flat to Z, Z won't be able to claim damages from Y for breach of the implied covenant because Y has no interest or estate in the part of the building which is in disrepair.
Well, Lord Justice Lewison might disagree with that. He might say you've got an easement of protection from the weather, if it exists, from the roof, and it carries with it the right to repair the roof if it falls into disrepair.
Logically, in view of what he said about the right to maintain a right-of-way, then Lord Justice Lewison might have said that, and I would respond in precisely the same way that I respond to the point about the right-of-way. I would say he doesn't. I would say you have to give notice, and you have only a last resort right where you have landlords repairing covenants.
Yeah. Okay. Well, I mean, in the end, it's open to us to disagree with Niazi.
Yes, indeed.
But I see why you rely on it. I see what you say. Yeah.
Yes. And I was also very, very briefly just going to take you to one paragraph in another case, which is Grand and Gill, which is tab 8.
Thank you.
And it's I accept, your lordships may say it's just a passing comment, but if one looks at page 702, at letter C, which is part of Lord Justice Rymer's judgment, he said, this again is a flat case, he says, Mr. Gill has a long leasehold interest in the flat, but no interest in the remainder of the building.
Yeah. Well.
And Niazi was referred to in the judgment, so one would assume Lord Justice Rymer had read what was said and is simply, he's taking the same point.
Thank you. Yep.
So other than that, there isn't any direct authority on the point. There's certainly nothing at this level. And so my submissions are effectively quite short, but would be determinative. I say this. I say, first of all, that for the purposes of section 11(1)A, an easement isn't sufficient estate or interest for the purposes of the implied term. And in answer to the question, well, what might interest be getting at? Well, in my submission, what interest might be getting at is beneficial interests. Because with trust structures, offshore companies and so on, it's certainly not impossible that there may be circumstances in which a landlord has a beneficial interest in the rest of the building, possibly with occupational rights. Another possible scenario, which one does sometimes find for tax purposes, is an equitable assignment of the landlord's interest. So that you have landlord A who has the legal interest, but landlord B is the equitable assignee who, for instance, would be entitled to receive rents from a subtenant. So that, in my submission, is why it wasn't limited to estate, which is quite a narrow term because that can only refer to a legal estate, i.e. a leasehold interest or a freehold. The second way I put this is that, as I put it at paragraph 3b of my note, which is having sublet, my client, for the purposes of section 11(1)a, has not retained sufficient interest in the common parts. And on any view, he had a very limited interest because the highest it's put is he had a right of way, a right to pass and repass. This comes back to the point about what does he have when he grants the tenancy. So might I divert for a moment to look at the assured short-hold tenancy agreement and to explain the point I'm getting at, because I don't think, in fact, when you come to read Malone and Friend's note, he hasn't quite seen the way I put it.
Right. What do you want us to look
So
at?
could I ask you to, for this purpose only, to turn up the appendix, please, and to look first of all at the lease and then at the assured short-hold tenancy.
So we're first going to look at the lease to
Yes.
your client, and then we're going to look at the underlease to the respondent.
Yes.
Okay.
So page 183, first of all.
Yes. So there's the head lease of the flat.
So this is my client's lease,
Yep.
and it's in the usual
Yep.
form. So you find a demise clause at page 191, clause 2,
Yes.
which says, in consideration of the premium, landlord demises the flat, together with the rights specified in Part 2,
Right.
and commonly excludes any implied rights under Section 62. And then at page 197, you find the rights granted.
You've skipped covenants by the landlord, Mr. Rainey,
I did.
on 192, clause 413, referred to by the Deputy District Judge, I think I'm right in saying, the freeholder does have repairing obligations to your client in respect of common parts, but no liability for breach in the absence of written notice.
Yes, that is right, and that's one of the reasons my client is in effect between a rock and a hard place.
Quite.
Certainly on the Court of Appeals,
Yes, very well.
because this effectively writes the head landlord out of
Yes.
the common law rule, but there's no law which says he can't do it.
Section 11 only applies to leases of less than 7 years. Yes.
Yes, there are other ones, but it certainly doesn't apply to a long lease like this.
But the interpretation of Section 11 can't depend on the terms of the head lease, can it?
No, I accept that.
Anyway, you're going to take us to rights on page 197. Which of the rights is it you want to look at?
Well, first of all, I was going to point out, because I do say it's important when considering what he's got left, is the first 3 lines, which is, first of all, it's the rights for the tenant in common with the landlord and all other persons authorised or entitled to the like rights, so that's all the other flat lessees, at all times and for all purposes incidental to the occupation and enjoyment of the flat. The reason I point that out is because, for instance, at 8 at the bottom, there is a right to park. But having sublet the flat, it can't sensibly be contended, for instance, that my client could park his car there if the tenant was away. Because
Well, he's got the right as against the landlord to park the car, but not the right as against his subtenant.
well, in fact, he wouldn't actually have the right against the landlord, because if he's not living in the flat and he was just going shopping, I mean, you can't say, well, I'm going to park my car there, or I fancy going on a holiday for 3 weeks and I need to leave my car somewhere.
He's got the right, but it's got to be within the opening words, of course. Yes.
Indeed. But the point I'm making is that having sublet the flat, granted exclusive possession of it, one's got to be very careful about the notion about exercising these rights, because you can only exercise the rights against the head landlord for the narrow purposes of the lease. You can't loiter around to his heart's content.
Yeah, but if Lord Justice Lewison's right, that doesn't help you, because he's responsible for keeping it. If he's responsible under Section 11, then he should be keeping an eye on the state of the common parts, and that's for the benefit of the enjoyment of the flat.
Where I would accept that there is a point is that Section 11.6, of course, gives him a right of access for inspection and so on,
Yeah.
and that would apply equally to the common parts as it would to the flat itself.
Yeah.
But your point here is that he doesn't have an interest because for the time being, is that it?
That's it. My point is going to be that an alternative way of looking at the reasoning of the Court of Appeal is that having sublet the flat and granted what I say is effectively he's granted away all of his rights, such as they are under this, for the term of the assured short-hold tenancy, that he doesn't therefore retain sufficient interest for the purposes of Section 11.1a. That's the point I'm going to make. But it's also... yeah.
Yes.
And just to finish looking at this, he's got the right at 1.1 to use the entrance hall, lift, staircase and landings, giving access to the flat. Your Lordship, my Lord, paragraph 4, you're quite right, has a right to shelter and protection.
Yeah.
One would expect to see that. He has rights to use the TV aerial. He's got the rights to use the access road. He's got the rights to use the bin store, which is where Mr. Edwards was going when he tripped over.
Yes. I mean, the point you make, I entirely see the force of the point you make as a matter of practice in the opening words of Part 2, Paragraph 1. But the truth is, isn't it, that if it is an interest, within the meaning of Section 11.1, if an easement is within the meaning of interest, then the fact that it's been, in practice, severely curtailed because he's sublet doesn't stop it being an interest, does it?
No, I see that well, to put it another way, I accept he's always got the reversion on the assured short-hold, and as soon as the tenancy is gone, he's got all the rights which you see set out on...
But you say even if it's an interest, when it's granted, when he sublets, as it were, and deprives himself of all the benefit of the interest, it ceases to be an interest within Section 11.1a. Is that really the point?
Yes, that's the second point.
Thank you.
Is there a plan which one can see where the bin store is? I'm not quite sure. And where the access...
There's a plan on 189 and 190.
There is a plan at 189 and 190, but if one wants to answer your Lordship's question about where the... if one looks at page 190, you see the shape of the building, and at the bottom, the part which sticks out is a storm porch. Yeah. You've got the outlining of the building, and the accident took place not far outside the storm porch. If you want to see exactly where Mr. Edwards said the accident took place, you'd need to look at page 243. It might be in a different part of the... Oh, you have the photographs. At page 243, Mr. Edwards is pointing to the paving stone.
I see. The bin store is somewhere where? I mean, these are parking places, the 1, 2, 3, 4.
There isn't insurance.
According to my learned junior, for what it's worth, that the bin store had burnt down, and it was in fact a temporary bin store in the car park, and I can't tell you where it was.
Right.
But anyway...
So the best way...
Sorry.
No, please.
On this analysis, if your client wanted to walk through the front door and across the front hall during the subsistence of this tenancy, he would need permission?
No.
Well, it depends why he was going. If he was exercising his rights as reserved under the assured short-hold, then no.
Yes.
But
Well, why not? Surely because most of his rights would be not for the benefit of his occupation and enjoyment of the flat, but he would be, either it would be with a view to him going back at the end of the tenancy, or it might be with a view to exercising his powers and duties to his own tenant, to the subtenant.
if he was doing it for that purpose, then I would accept that, yes, he could do it. But to take an extreme example, if he decided that it was cold and wet and he was going to couldn't find a train home and he decided he was going to sleep in the common parts, he wouldn't be entitled to do so.
But he wouldn't be entitled to do that anyway, because he's only got a right to use it for access. I mean, the truth is that the only reason he's likely to be there is in connection with the right, even if he's sublet. Because it's either going to be with a view to his enjoyment of the flat physically when he gets repossession against the subtenant, or it's going to be something to do with doing his duty by the subtenant.
No, I do accept that point.
Yeah, okay, thanks.
The only other, just while we have the tenancies available,
Yep.
I wanted to make good the point, because I think it's relevant to notice as well, about what the subtenancy actually demises.
Yep.
Subtenancy begins on page 212.
Oh, yes. Thank you. Yep.
It's a standard or a pre-printed sort of form of
AST, yep.
AST. If you turn over the page to 213,
Yep.
see the definition of the property which is let.
Yes.
And the way this deals with it at 1.5.1 is to include the
Yep.
easements as being demised.
Quite. So basically, it's, if you like, a subdemise of the rights he's been granted.
Yes. But there is a difference. There's a conceptual difference which is quite important. What he gets from his landlord,
Yeah.
the freeholder, is he gets a demise of the flat
Right.
and the grant of a common right, an easement. Whereas when he sublets, he demises the whole thing, including the easement. Because, of course, you can lease an easement, and that's
Yeah.
what he's done. So he's parted with his shared interest for the duration of the...
Yeah. In the same way he's parted with the flat.
Yes, exactly.
Yeah.
So my point is, and it is quite important, and the car parking space is probably the best example, he wouldn't have any right as against his subtenant
No.
to park a car, even though
right.
he has an easement to park against his own land.
Exactly.
Because his tenant has exclusive rights. Thank you. So, my Lord, that's the second point on that.
Thank you.
The third point elides into the further point which I want to make, which is, again, going back to section 11.3a, and this is the point made at paragraph 12
Yep.
of the case. It's very difficult, if he does have an estate or interest for the purposes of 11.1a, and Lord Justice Lewison is right about the right of repair, it's very difficult to see what room is left for section 11.3a, if, of course, you also accept what Justice Lewison said, you don't need notice.
Okay.
It works, I submit, if either Lord Justice Lewison is wrong about the rights or wrong about notice, or both.
Yes.
My Lord, that's all that I had to say by way of development of the written case on estate or interest. It's a very short point. It's either right or wrong.
Thank you.
The second point is whether or not the place where Mr. Edwards pointed to is having tripped over, as to whether that is part of the structure or exterior. And I would ask your Lordships immediately to reject the notion that it's structure. There's no support for that. It plainly isn't part of the structure of the building. The question is whether it's part of the exterior.
Right.
And first of all, I say that Lord Justice Lewison went wrong. He went wrong in two fundamental points.
And it's got to be the exterior of the building, not of the premises demise to the subtenant. Is that right?
Well, no. Lord Justice Lewison posed, I would say, the right question, because he said, you've got an easement on his analysis over the common hallway.
Yes.
And then he said, so that's a part of the building. So the correct question, he's right, is it this part of the exterior of a part in which there's an estate? I.e., is it part of the exterior of the hall? But
Of the hall?
Of the hallway.
Hallway, right.
But having posed that question, he then said, well, obviously it is.
Can you show where he says that? I'm sorry. Just to be clear.
We're looking at page 3. Is it 381 or so? Of the bundle.
Paragraph 6, isn't it?
Well, just bear with me while I turn up the...
Top of 382.
It's the top of
Lord
382.
Wilson's right, isn't he? Yep.
Just below letter B, can the paved area which leads from the front door to the car park be described as part of the exterior of the front hall?
Front hall.
Now, that must be the right question, given the rather convoluted drafting of section 11.1a. But I say, no, it plainly isn't part of the exterior of the hall. It's part, on the basis of Brown, it may be argued to be part of the exterior of the building as a whole. But once one is back to saying, well, no, if the question is it the exterior of a part, then I would say it is not an ordinary use of words to say that the pathway is the exterior of the hallway, viewed as a single part of the building.
So the important point is accepting, which you're prepared to do for the sake of argument, it's part of the exterior of the building, is not good enough. The question is it part of the exterior of the front hall, as Lord Justice Lewison says?
Yes.
So he poses the right question, but gives the wrong answer.
And he does give the wrong answer. And apart from saying, and of course it may be a good enough submission simply to say, well, it just as an ordinary use of language, does that hold water? And I would just say the answer is no. There is a more fundamental objection, which is, because of the way it's drafted, you're back to Campden Hill. Because Campden Hill dealt with the proposition that you have a flat or a dwelling house which is only part of the building. Then the Court of Appeal had to grapple with what is the structure or exterior of that part. So you get the same approach here. And I would say that what Lord Justice Lewison should have done is gone back to the Campden Hill case and adopted the same approach which Lord Justice McGaw adopted. So this is tab 4.
Yes.
And the key passages are on pages 610 and 611. Because you get, first of all, at just below letter G on 610, you get the lessor's contention.
Yes.
Which was rejected, which is that effectively it's the demise which governs the way the implied term works. And then at the top of page 611, you have the opposing contention of the lessees, which is a very broad contention. It's all a question of fact and degree. And just above letter B, they were saying it would extend to all of the exterior walls of the building, the whole block, for instance, similarly for the structure. Mm-hmm. And at letter E, Lord Justice McGaw, giving the judgment, says we don't accept the contention of either the lessors or lessees in entirety, although the true meaning is we think nearer to the lessor's contention than to the lessees.
But not near enough for them to win. Yeah.
Well, for my purposes, it's how the Court of Appeal approached it.
Right.
It says we don't accept the lessor's contention insofar as it would limit the structure and exterior to that which is demised.
Yeah.
But then they say the exclusion of the underlease wouldn't have the effect of taking it outside the operation. But then the important bit is between G and H.
Right.
It says that the paragraph applies to the outside wall or walls of the flat, the outside of the inner party walls of the flat, the outer sides of the horizontal divisions between flat 20 and flats above and below, the structural framework and beams directly supporting the floor, ceilings and walls of the flat. We do not accept the lessee's contention so far as it goes further.
And then he says there may be other obligations, but that's really where it stops as far as you're concerned.
Yes, although you have to go right to the end of the passage at the top of the next page.
Right.
Paragraph A of 32.1, that's the old section, is not concerned with them as constituting the structure exterior of the dwelling house, for they are not of the dwelling house. The paragraph expressly and deliberately uses limiting words. So what I would say is that was how it worked with a flat.
Yep.
Because it's a part. So you've got to do the same thing with a hallway if it's a part. So what the exterior of the hallway is the inner party walls, which divide the hallway from the rest of the building, the ceiling, which divides the hallway from the rest of the building, the floor, possibly the front door, because that's part of the end of the hallway. But that's all the structure and exterior of the hallway is. The path outside is the common pathway, which is the exterior of the whole building on the basis of Brown. But it can't, on any ordinary use of language, be part of the hallway. And I get the words, the ordinary use, again from Lord Justice Magore in the passage we've just looked at. It's anything, this is just below letter F, anything which in the ordinary use of words would be regarded as part of the structure or of the exterior of the particular dwelling house, regarded as a separate part of the building, would be within the scope of paragraph A.
Right.
And I simply, it's a short point, but I'm, in my submission, absolutely the right point, which is that if you take the hallway out of the rest of the building, look at it as a separate entity, you don't get the path.
Now, obviously, this isn't binding on us, it's Court of Appeal. Even if it says it gets you home on this point, it could be said we don't have to follow it.
No, indeed, your lordships do not.
There's the fact it's been around for nearly 40 years. I suppose that you can say that it's been assumed to be right in the sense that 11.1a was added to
In effect,
meet
reversed.
it. Yes. On the other hand, it could be said that's parliamentary indication that they don't like it.
It can be said to be parliamentary indication that they don't like it, but they don't like it because it's legally right, and as a matter of construction is right.
Yes, I see.
And
But they use the same language of structure or exterior. They don't.
it's the
find
same
necessary
structure and
sort of-
exterior test. And they, in Parliament, there are probably many ways they could have framed the implied obligation. In fact, one knows there are many ways because, I mean, there are other acts. I mean, for instance, the equivalent Scottish legislation is drafted differently. But what they did was they deliberately said that it has to be a part of the building in which the lessor has an interest. They could have simply said it's the whole building and left it to some form of statutory defence, but deliberately
Yes,
Section 1.1a was confined.
Thank you.
And having so confined it, in my submission, the pathway simply can't be the exterior, and therefore one never gets into the fact and degree test.
Okay.
Because I know what my learned friend will say. He says, oh, it's a matter for the district judge, fact and degree, can't attack it in this court. But if, of course, the district judge is wrong in the way he approaches the construction argument, and if Lord Justice Lewison is wrong about that, then we never get there.
What do you say about Brown and Liverpool Corporation? I mean, it's not necessary for us to decide it was right or wrong, but there is some support, is there not, for the proposition that A, it's given a wider meaning, and B, it's a question of fact and degree?
There is, but Brown and Liverpool is a house case.
Oh, quite.
And it's quite easy. One doesn't get into the distinction because there's no part of a house. So one can see how the Court of Appeal just about said that the steps which, and bear in mind the steps, if you read Brown and
Right.
Liverpool carefully, the steps are at the street side,
Right.
not the ones on the house.
Right.
You've got to go 7 foot down a path and then along. Just about found that was structure exterior. There is, in fact, a case which isn't in the bundle, and I could hand in, called Hopwood and Cannock Chase District Council, where the Court of Appeal effectively said that Brown and Liverpool went as far as one could possibly go, and they express a lack of keenness on the decision.
You mean, in other words, they were saying it went further than it could possibly go.
But
Couldn't
they
say
actually
so.
go quite
Anyway,
a long way to saying that they go as
Okay.
close as they could,
well,
I think, to saying
if
it was
you-
wrong. But
I'd be, if we could have it in just to see it, but don't let us have it later. Yep, thank you very much.
You have the reference to it now.
I do, my lord, yes. It's
I think you've got copies of it, Anita.
I do. I do have enough copies to hand in.
Yes.
It's 1975, One Weekly Law Reports,
Well,
373.
you're not asking to read it out, but you're drawing it to our attention.
I am drawing it
Thank
to
you
your
very
attention.
much.
I don't think I have time to read it out.
Fair enough. No, I'm not encouraging you to. Thank you very much. Yep.
And I think just to finish that one point, I think my learned friend will say the Deputy District Judge assessed all this, but one must remember the Deputy District Judge was applying entirely the wrong test because he was looking at 11.1.
Right. Okay, thank you very much.
So that then brings one to the notice point, which is
Yes.
probably the longest of the points. And if I can just set out the various ways I go about setting this out. First of all, I will go for the very simple, straightforward argument that there is a blanket rule following O'Brien that you simply need notice in Section 11 cases.
Yep.
Second, as set out in the note, I submit that the common law rule, properly understood,
Yes.
requires notice where the landlord doesn't retain possession, occupation or control of the areas he's covenanted to repair. Thirdly, going back to my point about what he's got, where he's only got a right of way,
Yes.
for the purposes of the common law rule, simply having a right of way over the hall isn't enough to constitute him in possession, even if he hadn't sublet it. Fourthly, as I've pointed out, there is a demise under the assured short-held tenancy of the easement. So another way I could put it is to say, well, if the common law rule is expressed by reference to demise or not, as a subtenant, he does have a demise of such rights as my client has over the common hallway.
In a sense, you're saying the fourth point is source of the goose, source of the gander. If it's enough to be, if the letting of an easement is enough, then the subletting is enough to take it out, as it were.
Exactly.
Yeah.
Alternatively, as it's put in the case, if we need an extension, then that's what we ask for, because there isn't a case which precisely addresses the circumstances of the modern multi-occupied building.
So it's a five-stage argument.
Well, I had a couple of extra stages.
Oh, right. If you need an extension, then where do we go next?
Well, circling back to a degree, there are peculiarities attending Section 11, which might, if it were needed to tip the balance, go for Section 11. The first point is it is imposed, although it's a contractual term in the way it takes effect, it's imposed by statute and it cuts across contractual relations. It matters not that notice is required under the head lease, as your lordship said.
Yes.
And that
Yeah.
is a relevant point. It is possible technically to vary Section 11, but you need the permission of the county court, and it's completely unrealistic to suggest that every AST landlord in the position of my client in that block should go to the county court for permission, for instance, to put notice in, because there's notice in the head lease. And the point I've already made about Section 11.3a, the statutory defence very clearly indicates that notice is required. So those are my the arguments in summary.
Yeah.
My lord, perhaps the key point is what the true common law rule actually is. I mean, that's the point of widest implication. And I would propose to take your lordships through some of, not all, but some of the expositions of the common law rule, which I think support my proposition.
They're set out in the written cases, but not all, possibly. I don't know.
Well, this is probably a more convenient
Okay.
way of doing it.
Okay.
First of all, if I can, and I'll do it as quickly as I possibly can, my lord, obviously. Dowding and Reynolds, which is the leading text on repair, which is in the joint text bundle at tab 8. Page 550. At the bottom of the page, the learned authors there, having looked at Murphy and Hurley, submit that the common is really their opinion, or opine that the common law rule is no notice is required where the subject matter is not part of the demised premises but
Sorry, I'm
remains...
not with you. Where's that?
The bottom of page 550 in the bundle, last
Yes.
3 lines.
Follows that no notice is required.
Where it's not part of the demised premises but remains in the landlord's possession and control.
Yeah.
The landlord's possession and control point.
Yes.
And in respect of, if I can then ask you to turn back to page 532.
532.
532.
Yes.
It's halfway down the page, notwithstanding the above.
Yes.
Thought that Prince and O'Brien is of general
Oh, yes.
application. Well, that's the general application argument of all Section 11 cases. And then 2 at the bottom talks about the amended Section 11. And it's important because at the end of that passage, at the top of page 533, They say, it follows the tenant's likely to be the first person to become aware of the existence of defects. This is particularly so where the landlord has not retained possession or control of the relevant part of the building or installation, although it may be that in such a case notice would be required even at common law. And I say, yes, notice would be required at common law. And the footnote at 186, which is what that refers to, i.e. because the subject matter of the covenant is not within the landlord's possession or control.
Does the question ultimately of principle boil down to whether it's in the landlord's possession and control, and only if it's within his possession and control, is there an absence of a need for notice? Or is the need for notice confined to cases where the tenant's in possession? Are there any cases where which consider the need for notice in the context of somebody other than the landlord and the tenant being in possession of the relevant part?
I can think of, there's a possibility which has been introduced by statute.
Yes.
Which is, there's actually a note in Dowding Reynolds about it, which is if you have a right to manage company.
Yes.
If you have a right to manage company, it's a right to manage company which becomes liable to the occupational tenant under Section 11. So they would be neither the landlord nor the tenant.
I was going to say that falls between two stools. The management company is in possession and therefore may have the liability. But it can't have the liability because it's not the landlord.
There could be cases where you have a tripartite
Yes.
spat lease and they don't have any interest. They
Right.
simply have a covenant owed to carry out the work.
And what's the position with the right to management company? They have to have notice or they don't?
It doesn't say.
I see. You're
What
But
statute
if the
does.
management company is in possession of the common parts,
It would all depend on the structure, because sometimes management companies have a lease of the common parts.
right, exactly. Well,
But
what happens?
sometimes they don't.
But are there any cases where Section 11 is invoked in such a case, or no reported case, presumably? Anyway, okay.
Not that I'm aware. I think
Okay.
we have almost everything on the top.
Quite. Okay, fine. Thank you very much.
Bundle. I mean, no doubt it's an interesting point for another case.
Maybe this case. Yeah,
The-
okay.
That's what Dowding and Reynolds says, having looked at the cases.
Lord Justice Lewis has accepted this was, as it were, in your favour, but he says it's wrong.
He does say that Dowding and Reynolds is wrong, but I say Dowding and Reynolds is right, because Dowding and Reynolds were referring back, among other things, to Murphy and Hurley, which
Right.
is a decision of the House of Lords, albeit I suspect not technically needing to be followed because it's an appeal from Ireland, but nevertheless a decision of the House of Lords in 1922, which is tab 19.
Right.
And Murphy and Hurley it's an interesting case, because what Murphy and Hurley in fact says is that the fact that it's demised to the tenant is not necessarily determinative if, unusually, the landlord retains control. Because in Murphy and Hurley, I think by the time the case got to the House of Lords, it wasn't entirely clear as to whether the seawall was potentially demised within some of the leases, because they were judicial tenancies created under a statute which I confess I can't explain. I don't know how it worked, but one can see in the speeches that it was effectively this judicial construct. And so it wasn't clear as to whether it was let or not, but the House of Lords actually said it doesn't matter because the landlords retain sufficient control. But the key passages, I would submit, the best passages in the particular case, I think, are on page 387, internal 387, which is 868.
Thank you.
This is part of the speech of Lord Sumner, and page 387, and 6 lines down from the top, it says, it follows, the obligation to repair might well arise in favour of a particular tenant who had neither possession nor control of the particular part of the wall, and then he says it doesn't matter whether in fact it's demised, which is contrary to putting everything on the demise, and it says in 2 cases at any rate, it clearly was not so. It says, if the landlord retained possession and control, which for certain purposes he clearly did, then Mellis and Home, 1918, is authority for saying he would not be entitled to notice of want of repair. So there, Lord Sumner is saying it's not about demise, it's about possession and control. And there are a number of other potential references in that case, but that's taking it from Mellis and Home, and Mellis and Home does indeed put it that way. That's tab 17. One can also derive support for this from another decision of the House of Lords in McCarrick, which is at tab 16. Page.
Is Mellis and Home really support that proposition? I mean, in Mellis and Home, it was the letting of rooms, and the landlord retained possession of the roof, and the roof was out of repair. Am I right or not? But then,
It's simply the way it's expressed.
I see why I see how you say Lord Sumner helps you, but I don't understand why Mellis and Home helps him. Can you explain?
Well, I think it's to do with the way the judgments in Mellis and Home
I see.
are actually expressed. I mean, for instance, the passage he's referring to, I would say, is probably one on page 824 of the bundle.
Yes. The roof was in the possession and control of the defendants, about 8 lines up.
8 lines up from the bottom.
Yes, because the roof was in the possession and control of the landlords, they hadn't let it.
Yeah. Well,
If you've let something, it isn't in your possession, and if you have let it, it's not.
Indeed. So that's why you get to Sun Life. That's why, and it appears then that one can simply draw a line demise or not.
Yeah, I see.
But life is more complicated than that when you have multi-occupied buildings, such as a block of flats. And then you get the point that, well, the landlord in this case is a sub-landlord who never had anything more than an easement. And the easement he's got, he has in fact let completely, so far as he can, to his subtenant.
Yes, I see.
It's effectively, it's arguably a grey area, but I would say, in fact, one has then got to go back to whether the rule really does depend on demise or not. In the view of Murphy and Hurley, it can't.
Anyway, I see how you get assistance from what Lord Sumner says. Yep, okay.
And I do say that's where Lord Sumner obtained the basis for what he said.
Yeah, well, I think he did.
Even in the British Telecom case...
We're going to McCarrick, or you know.
Sorry, yes.
Sorry, yes, I interrupted you, I'm sorry.
Thank you, my lord. Yes, I was going to Carrick. Which is the previous tab 16.
Yeah.
And in fact, the passage I was going to take you to on at page 811 is in fact the same passage from from Murphy and Hurley, referred to by Lord Porter. But the point is, it's being referred to again. There are in fact interesting and important justifications for the common law rule, which are set out at the halfway down the page onwards. But at the bottom of the page, again, you get this reference to the landlord, Mellis and Home. No notice was given by the tenant. The landlord had knowledge aliunde of the want of repair. Nothing I've said is meant to affect that or to lessen the landlord's obligation where he keeps part of the premises under his own control and has a constant opportunity of observing the state of repair. So there's that, and there's also on page page 814, you've got Murphy and Hurley being referred to again by Lord Simmons, and Lord Simmons says halfway down, the salient fact was that the seawall, so far as being in the exclusive occupation of any tenant, was, as Lord Buckmaster said, intended to be within the control of the landlord. So, again, the way Lord Simmons is putting it is that it's the control issue. And what I say is that it, again, diverting slightly from the cases I was going to refer to, it's easy to see why it looks in most cases if it's easy to draw the line at demised or not demised. But there is this area where the landlord doesn't in fact have control over the area over which the covenant is supposed to bite. And in my submission, if you have that kind of case, such as here, where you're the intermediate landlord and you've only got a very limited right in the first place, then it is the, if you want to call it an exception, then it's an exception, but notice applies. You have to give notice. And indeed, that is actually how it was argued in the British Telecom case. If I could very briefly ask you to look at page 590. Because the BT Sun Life case is at tab 2. At A, at the top of the page, it records the submission of Mr. Reynolds, who appeared for the landlord, and his submission was, he accepts that since the premises affected by the defect are either in his possession or under his control, the landlord must be treated as having the necessary knowledge of it.
Sorry, where is that?
Top of page 590.
Sorry, I didn't hear that. Thank you very much indeed. Yes, I got it.
So that was the submission. Now, I appreciate that the Court of Appeal expressed itself by reference to demised or not demised, but the submission I'm making was in fact the one which was made in Sun Life. And if it's necessary to say that Sun Life didn't quite state the rule correctly, then I would say that.
Just as for the record, Mr. Reynolds refers to either in his possession or under his control, whereas the passage of Viscount Sumner was both, not either. Does that make any difference, or doesn't it matter?
I would submit not, certainly not on the facts of this case.
Right.
And if possession means legal possession, then I suppose I could say that an easement doesn't confer legal possession.
You can, yes.
But from my perspective, I would say that my client had neither possession nor control. Indeed, he probably never had possession or control to start with, but certainly as far as between him and his subtenant, he doesn't have it, and his subtenant needs to give notice.
One of the problems is that these cases, of course, were all concerned with premises which were demised, not premises over which there was a right. One of the problems is that they weren't addressing or thinking about cases involving easements, were they?
No.
Where there was a right of easement.
No, because the BT case was the cladding on the external face of the building,
Yep,
so
right.
the point wouldn't have arisen. Yeah. One point where it did come up, and it was considered in the context of this case, is in the judgment of my Lord Justice Carnworth in Carroll, Ambus and Earl, which is at tab 5.
Thank you.
This is the addendum to the judgment, but at page 616.
How do you know it's me? I didn't sort of recognise it. But
I think I knew that because I've seen the rest of the judgment, which I think was your lordship.
I'm not denying it, but
Yep.
There are two paragraphs which are important. There's paragraphs 8 and 10.
Thank you.
Paragraph 8, I would say, correctly states the law. I would say, in applying a standard lessor's repairing covenant, the law draws a distinction between disrepair in the demised premises themselves and disrepair in other parts of the building within the lessor's control. And again, sort of identifying this point. In the latter case, the general rule applies. There's then a reference to British Telecom, and then there's reference to exceptions to the general rule. But then at paragraph 10 of the page, my lords and the whole court said, we'd add one comment. The BT case and earlier cases relied on in it were not concerned with the modern statutory and contractual framework governing residential leases. Repairing obligation in such a case as the present is not freestanding. In practice, it's linked to the obligation of the lessees to contribute to the costs so incurred. And then at the end, having discussed that particular lease in a future case, it may have to be considered whether the general rule as laid down by BT requires some modification to take account of the practicalities of the modern relationship of residential lessors and lessees. And I say, yes, I mean, it may be that it doesn't if the common law rule is correctly stated, but if the common law rule does draw a bright line between demised or not demised,
Yep.
and if you were against me on the fact that the easement has been demised by this assured short-hold tenancy, then I would say, yes, the British Telecom case ought to be revisited, and a third category, if you like, ought to be identified, common parts, which are not retained in control of the lessor who is bound by Section 11, and in that case, notice is required.
But again, the BT case was not concerned with a multi-occupation building.
No, the decision was, I have no difficulty, I'm not suggesting the decision itself was wrong, what I'm suggesting
The phraseology.
it's the phraseology.
Yes, very well.
Yes.
So those are the key points in my submission on the common law rule. As I said, I've also bring into it, and I would therefore repeat now, all my client ever had is this shared right of way. You can't be in possession of that, and he demised it away. We then, in my submission, would lodge...
But the whole function of an easement is not to part with possession. The grantor of the easement remains in possession of the relevant property, you
Yes.
say, and therefore possession remains in the head landlord throughout.
Yes. So
he on this basis would be liable under Section 11 without notice because he would be in possession.
yes, if, for instance, my client's or somebody's flat had been forfeit and had fallen back into the possession of the head landlord, and he had sublet it rather than granting a new long lease, then no notice would be required because he would be in possession of the common parts.
Yes. I mean, put another way, if it had been your client who had tripped as the tenant, then subject to other points, he would succeed against the landlord because the landlord was in possession.
Yes.
But because it's a subtenancy, and it's different because that the landlord under the subtenancy, i.e. the tenant, is not in possession of the common parts. That's your point, really.
It is. And it's a terribly important point because, of course, buy-to-let investment in residential flats held on long leases is prevalent. So the number of...
You don't have to persuade us whether it's important or not because you're here. We need to decide the point. Yep, but I see your point. I obviously, the number of cases is quite, on this recently demonstrates that. Yes.
And I think the next point, which I ought to elaborate on, because it's relevant in a number of ways, is to go back to this point about whether Lord Justice Lewison was right or wrong about the implied rights of someone who has a right of way. You've seen my client's lease, which gives him the right to pass and repass for purposes incidental to the flat. So it is a pure right of way case. Lord Justice Lewison said in his judgment that, and as I understand it, it's on page 383.
Yes.
At paragraph 11 in the Court of Appeal, he said, where, as here, there's been an express grant of an easement, the grantor will carry with it the ancillary right on the part of the dominant owner, that's my client, to carry out repairs to the servient owner's land in order to make the easement effective. In the case of the grant of a right of way, the dominant owner is entitled to repair the way. Gale on easements, paragraph 191, Newcomen and Coulson.
Yeah.
For the reasons which I adumbrated in the additional note, I do say with great respect that that's, as a statement of the law, that's just wrong. The ancillary rights arise by implication, and like implied terms, they arise when they're necessary. And there is authority for that.
Normally, with an easement, if I grant you an easement over my land, over a road, I have no obligation to repair the road.
That's right.
And therefore you say it's necessary to imply a right in favour of the grantee or it's appropriate to.
Yeah, because otherwise the roadway may fall into disrepair and then the
Nothing.
purpose will be frustrated.
Yeah.
So they have a right but not an obligation to repair it. And there are quite a lot of cases on this, and depending on the terms of the grant, they may have the right to make up the way. They may or may not have the right to improve the way.
Is there any case where there's been the grant of an easement where the grantor has a covenant to repair, and it had to be considered whether in those circumstances you imply a right in the grantee to repair?
There is an unreported case which is actually referred to. There's a case called Carter and Cole, where there was an argument between two freehold owners about the right. And effectively, there were covenants, but each side was saying the other couldn't go in. And the Court of Appeal said, well, they both could go in. But if your lordships or your lordships' assistants dig out that case, then the reason it probably doesn't take us anywhere is because there was an agreement between the parties which referred to a leasehold owner, because one of the properties was subject to a lease, and it was actually agreed, and it's recorded from off the top of my head, it's paragraph 11 of the judgment. It was recorded that the leasehold owner, who had the benefit of the leasehold easement, didn't have a right of repair. But I can't say that it's authority for my proposition because it was simply agreed between council.
Yes, I see.
So I'm going back to the statement in Gale on easements. What are you saying is wrong about that?
Well, Lord Justice Lewison simply looked at paragraph 191.
Yes.
What he should, I would respectfully say, is looked at the principles which are set out in paragraph 190.
Have we got that?
Yes, page 987 in the appellant's note, separate bundle.
Which page are we looking at?
Page 987, my lord.
Okay. Right.
The actual principle is a broad one in the first paragraph. The grant of an easement is also the grant of such ancillary rights as are reasonably necessary to its exercise or enjoyment. The ancillary right arises because it is necessary for the enjoyment of the right expressly granted. Sorry, it's the
It's attached to your note,
it is.
but why does that help you?
Because it emphasises that there's no blanket proposition that you obtain if you have a right of way, you have a right to enter into premises, onto the servient tenement in order to carry out repair. The proposition is that you have such rights and only such rights as are reasonably necessary for the exercise of the easement. And the point is that in a landlord and tenant context, in a block of flats, where you have interlocking covenants, for instance, the service charge, the repairing obligation and the control of the head landlord,
Yeah.
there is absolutely no necessity for someone in my client's position to be entitled as of right to go and repair.
No. I mean, forget about the subtenant. If it's just your
Yes.
When it
client.
is my client, yes, indeed,
Yes,
forget about the
your
subject.
client.
Yeah.
He discovers there's disrepair in the
Common parts.
common parts. He notifies the landlord, and the landlord does it.
Yeah.
So he doesn't have a right himself just to go and do it.
No.
Your point is he doesn't need it, whereas in the normal easement case he does, because there is no right to require the grantor of the easement to keep the relevant property in repair.
Absolutely.
Yeah.
And indeed, it would be, I think most investors in the reversions on blocks would be utterly horrified by the notion that anybody who had a lease of a flat could say, well, you know, I think that the common hallway is in disrepair. I'm not going to bother telling the management company because I'm a dab hand at DIY. I'm going to turn up on the Sunday with a couple of friends and we'll repair it. We'll repoint. We'll replaster the common hallway. It sounds
Well, we can, yes.
as if I'm taking an extreme point, but it in effect has happened because you have at tab 3, you have the Metropolitan Properties case. And in that case, the head landlord obtained an injunction because the tenants had come to the end of their tether with the landlord's, as they saw it, consistent lack of repair and so on. And so they said, well, we're not going to wait. we're going to put scaffolding up and we are going to maintain the building. And the Chancellor, Mr. Justice Etherton, as he then was, granted a mandatory injunction requiring them to remove the scaffolding. But the point is, the reason he did it was that what he accepted was that you effectively have a last resort right. Tenants of multi-occupied buildings, they do have a last resort right. If you've given your landlord notice and they haven't repaired, then you do have the right to carry out the repairs yourself, the self-help remedy. But it's a last resort. And as the...
Exactly.
my Lord, this again is attached to the appellant's note.
Yes.
And
It starts at page 991, yeah.
It starts at page 991 indeed.
Yes, but, so which page of the report do you rely on?
Well, the point I was just making appears at page, paragraph 64, page 1007.
If I were to permit the defendants, yeah.
Because there, Mr. Justice Etherton points out the consequences of holding that the tenants have got an untrammelled right.
Okay,
Yes.
yep.
Sorry, where is that? I'm not with you.
Page 1007,
Yeah.
Page
paragraph
27
64,
page 27 of the bundle, yep.
where he says, if I were to permit the defendants to carry out works to the interior, so it wasn't just the exterior, it was the interior over which they had easements, it would mean permitting the carrying out of works in relation to which there's been neither consultation nor agreement between lessees and defendants, etc.
Yes.
And then he points out, of course, if they really had the right to do it, then they would doubtless deduct the cost of the work from their service charges. This would alter the contractual leasehold framework, which casts upon the landlord the right and the obligation to carry out works of repair, disapply the statutory procedures which are designed to enable the tenant to challenge reasonableness. There would accordingly be a reversal of contractual rights and obligations and a negation of the statutory framework. Because in a sense, as my Lord, Lord Newberg and Lord Sumption and Lord Wilson will see, this is effectively Dejan and Benson in that you have it's the same group, you've got the same sort of allegations. In fact, you have the same contractor, Mito, which was supposed to be going to do the works. But in this case, instead of challenging it in the tribunal, the tenants decided to take the law into their own hands, and Mr. Justice Etherton stopped them.
I mean, basically, you haven't taken us to the covenant, but the covenants on page 208 are relevant, aren't they? Because read together with the landlord's covenant to repair in clause 4.1, there is a covenant to do this sort of work by the landlord.
And so the short answer is, what should Lord Justice Lewison have said, and what Lord Justice Lewison should have found, is that in this kind of case, and the covenants here are common, they're the same as the ones in the lease, the tenant's right of entry, if it exists at all, is a last resort right of self-help where you've given notice to your landlord, you've said, please do X, Y, and Z repairs, and the landlord hasn't, and are showing no signs of doing it.
Understand.
And then in that, you may have a last resort right. And as I say, otherwise it doesn't work at all. Because if once you accept that the tenant has the right to repair, then that means they don't have to bother giving notice. And as I say, any tenant in the building could do any form of work, they said, because it's necessary to remedy disrepair. And that would be, I would say, quite extraordinary.
Thank you.
So, in a sense, where does that get me? Well, where it gets me is back to section 11.3a.
Yes.
Because on Lord Justice Lewison's analysis, really, section 11.3a wasn't terribly relevant, because he was finding that my client had the right to do the work, whereas I would say my client didn't. Now, on the way I put the case, section 11.3a works, provided that there is notice. So if one goes back to the section, which is in the joint texts bundle, page 485 in tab 4.
Yes. 11.3a, yep.
11.3a. Lessor's repairing covenant effect under 1a. Well, tick, yes, we have that. In order to comply with the covenant, the lessor needs to carry out works or repairs otherwise than in the dwelling house. Tick. C, the lessor does not have a sufficient right in the part of the building concerned to enable him to carry out the required works or repairs. Or tick, because we know that no notice was given, so he didn't, on any view, he couldn't conceivably, I would say, have any rights at the point at which the claim arises. Then in any proceedings related...
I don't understand that.
Well, that's circular, isn't it?
Well, because it was conceded that the claimant, the respondent in this appeal, did not give notice to my client, and therefore my client, of course, had not given notice to his landlord.
But that's all circular because it assumes that the claimant has to give notice to your client, which is the issue we are deciding.
No, for this purpose, the question is whether my client had a sufficient right to carry out the required works.
Yes.
In the absence of, I say that if one construes the ancillary rights correctly, my client did not have any rights to fix this paving slab.
Well, you've got to be careful. We're talking about right as against the landlord or right as against... No, on this hypothesis, there's an obligation to the subtenant to do it.
Yes.
Now, if he had that obligation from the moment he knew about it, then he should... if he had the obligation from the moment the disrepair occurred, then he should have given notice to the... On your theory, he should have given notice to his landlord about it and said, get on with it. And he didn't do that. You say, oh no, he didn't have to do that till he had notice from his subtenant. But the answer to that is, that's the very issue we're deciding.
No, it's not as circular as that, because for the purposes of the Section 11.3a defence, which arises only once he's sued in court, the question is, did he have a sufficient right to enable him to carry out the required works or repairs? Now, the answer to that is a freestanding answer, and the answer is no. For whatever reason, and we know why, but for whatever reason, he hasn't given notice to his landlord, and his landlord is not in breach of covenant, and he doesn't have a self-help remedy.
No, but surely, you look at the nature of the defence, he's done everything he could. Surely the argument against you would be on this basis that if there's no requirement for notice from the subtenant, then you should have given notice to the landlord as soon as this disrepair occurred and started the ball rolling. And the fact you didn't mean you hadn't used all reasonable endeavour.
Yeah, but the trouble is that on the fact that this is a one-off trip, so it doesn't get my client anywhere. As Lord Justice Lewison observed, the only effect of Section 11.3a would be that if you had a continuing breach, you could stop the clock and stop the clock on the tenant's damages. And as I've observed, that rather puts it backwards. I mean, the tenant on that basis gets damages until he makes the mistake of telling his landlord, whereas it should work the other way round.
Well, I see how you put it on 11.3ac. Yep.
Well, it is, in my submission, fairly fundamental because the way, the combination of the various findings of law of Lord Justice Lewison completely emasculates Section 11.3a. And what I say is that Section 11.3a was plainly intended, assuming there's an estate or interest, etc., it was plainly intended to provide a defence to someone in my client's position. Section 11.3a was introduced with 11.1a. It is therefore fair to say that it's introduced in the context of dwelling houses which form part only of a building. So the usual background of blocks of flats must have been in the draftsman's mind. So what is 11.3a supposed to be doing? And I say it's supposed to be dealing with someone in my client's position. They don't have any rights to carry out the repair. In effect, it is not fair to saddle them with liability, so we get a get-out.
One possibility is the lease might actually say there is no right to carry out works on the common parts in the tenant, which there isn't here, and 11.3a would be that then be necessary. It would be invoked, wouldn't it?
You could have a lease which said that. I appreciate I haven't seen every lease in the world. I can't remember seeing a lease which specifically...
To be fair, nor have I.
It would not be the usual form of drafting, I would
I accept that.
But what I don't quite understand at the moment, I mean, assuming you don't have a right without giving notice to your landlord, but as between you and the subtenant, you have an obligation, then surely that triggers your obligation to give, under the last bit, to do everything you can to get the rights, which means giving notice to the landlord. If you haven't done that, then
plenty of others.
So it works perfectly well on that basis.
Well, he's had his time now.
It doesn't help you.
It rather depends, doesn't it, as to whether one could say, and I make this point in the note as well, can it fairly be said that someone who has no knowledge that they should be doing something is in breach of an obligation to use reasonable endeavours to obtain a right. So my client has no idea that the step is in
But I
disrepair.
mean, the premise is that he should have, that if he has a continuing obligation, the premise is that it's up to him to make sure he does everything necessary to get the knowledge.
Well, I would say that the...
I mean, that may be, that goes back to the notice point, but if
Well,
we're wrong on that, then I can't see why.
I think we've probably had enough on 11.3a. We have your point. Yep.
My Lord, it's a short point, but of course I did say that I was going to deal with the enjoyment part as part of this. I haven't actually. The enjoyment issue is a separate issue at the end of the appellant's case. It's to do with the meaning of subsection 1 capital B. It's not the main plank of my case, but when considering whether or not there should be the implication of notice, I would submit that it is significant that the covenant, as introduced by subsection 1 capital A, doesn't go as far as the primary covenant in 11.1. It says,
Yes.
as your Lordship will recall, nothing in subsection 1A shall be construed as requiring the lessor to carry out any works or repairs unless the disrepair is such as to affect the lessee's enjoyment of the dwelling house or of any common parts. And the short point which was made is that the lessee, who's presumably using the common parts, is in by far the best position effectively to know when there is something which is interfering with his enjoyment of those parts. It's not sufficient, for instance, that there is some element of disrepair if it really doesn't matter to him. And that is the point, and that points in my submission again to the implication of notice in the context of subsection 11, 1A. My Lord, might I have a moment?
Yes,
Because I can see that we've reached...
Yes, just when I said I thought subsection 3A it had sufficient on that, you've dealt with all the other points you wanted to on notice.
My Lord...
I'm not encouraging you to say any more about notice, but I didn't want to give the impression that I'd stopped you on I thought we'd had enough on 3A. It doesn't mean if you wanted to say anything else on notice, do, but I wasn't seeking to shut you down on anything else on notice. But as you may have said everything you want. I'm
Well, my Lord,
not suggesting you haven't.
your Lordships haven't read yet Milan and Friend's note.
No.
So he says something about the rationale for the common law rule.
Yes.
Since your Lordships haven't read the note, it might be better if I dealt with that in reply.
Okay.
Because there are a number of rationales for the common law rule which one can get from...
Okay, well, if you say anything in reply which is new, given that you've raised this whole point rather late, I'll give Mr. Benson the opportunity to reply briefly on it. But if you want to take that course, it seems a perfectly sensible course to take.
I think I would find myself in some difficulty in responding to something your Lordships haven't read.
I understand that.
The only other point which I haven't addressed at all
Yes.
is as to the nature of the implied term. Because, as we've identified, there are, of course, two possible ways of looking at it. Is it a Moorcock or an Arnold and Britton implied term? Or is it, in fact, a Guise implied term, where it's an implied term which is implied because, effectively, of the nature of the relationship, rather than it being a strict test of necessity? And the question which might arise as to whether, in fact, that makes any difference at all, because I know that
Might indeed.
the learned friends say, well, it's still necessity. In my submission, it may make a difference, and the test must be different, because the two types of implied terms are different, And they have at least one significant difference, which is that the second category identified by Baroness Hale in the Geese case concentrates more on the circumstances of the relationship between the parties than the precise contract which is before the court or tribunal. And she refers to the judgment of Lord Justice Dyson in an earlier case, where he said that there was a more flexible approach to the implication of such terms. And indeed, you can get that from the judgments, the speeches, I should say, of their lordships in Liverpool's City Council and Irwin, because there's discussion there as to whether, in fact, if it's a class term, you really need the strict necessity which you need under the Moorcock and as re-emphasised by this court in Arnold and Britton. If it becomes important, then I would submit that we are in the second category, in the Geese category, because, for instance, some of the earlier cases justify the implication of a term on the lack of any ability on the landlord to enter into the tenant's premises for inspection. But it was fairly quickly recognised that actually in most leases the landlord does have a right, and if a landlord has a covenant to repair, then there is an implied right to enter for the purposes of repair.
Was subsection 6, which gives the landlord the right to enter the premises, was that always part of, was that in, well, I can have a look, I suppose. That was in section 32, was it as well? Or not?
From recollection, the right of entry...
Section 32(4), yeah, on page 466.
Yes.
It is there.
But it's also, the earlier cases, of course, are common law cases. But they're common law cases dealing with,
yes,
with a simple lease between landlord and tenant. And if one looks back, it evidently was quite common, even in Victorian times, for there to be a reserved right of entry.
Yeah, it was in section 2, subsection 2 of the 36 Act. Yep, thank you.
Yes. So in fact, the right of entry has always been there. But the point I was making is that early justification that the landlord simply couldn't go in rapidly dropped away. And the court said, well, actually, that doesn't matter. It's all to do with the relationship of landlord and tenant and who is in the best position to judge the necessity for repair, etc. And so I would submit that at a point which one could debate, but certainly by the 1940s, and the case of McCarrick, one has moved, and Morgan and Liverpool is another example, one has moved from the strict Moorcock scenario into the Geese scenario. So if I did need some leeway in making my case for the implication of notice, then I would submit that your lordships ought to hold that this is in effect a class situation. It is a Geese type of case, and that the strict necessity rule doesn't apply, that it is more flexible, and that in the circumstances of a multi-occupied building such as this, if I need an extension, then the common law rule should be extended so as to require notice.
Yes, thank you very much.
Is there anything further with which I can assist your lordships at this stage?
Thank you, Mr. Rainey. Mr. Gunn Cunningham.
My Lord, I'm not making further submission.
Thank you very much. Mr. Benson.
My Lord, the question of whether the easement was sufficient to amount to an estate or interest has assumed possibly now, particularly in the light of the additional argument, a rather critical importance. I wonder whether to assist the court, and indeed me, my additional note could be read at this stage.
Yes. Of course. I relocate it. Read it here, can't we? Yes. Or should we? Well, if you'd like to sit down, we'll read it here. Read it now. If I may say, paragraph 2 is very realistic. Thank you.
Yes.
Yes, Mr. Benson, thank you very much.
The conclusion of Lord Justice Lewison that the hallway at the block of flats where the appellant's flat was located amounted to a common part of the building in which the lessor had an estate or interest is clearly, as I said a little earlier, a critical finding, because unless it amounted to a common part in which the lessor had an estate or interest, the case fails. So the issue of the easement assumes an importance, particularly as the appellant's case now is, and it seems to be accepted that the appellant did have an easement to use the common parts, but that easement, the enjoyment of the common parts, as between him and the respondent, disappeared, because when he leased the flat, he dispensed, as it were, with the shared right that he had in the common part. Hence, there is no interest that he has, and hence he had no control insofar as an interest gave rise to control, if not possession. And therefore, because he had no interest, the case fails. Because he had...
That's his second argument. His first argument is that an easement isn't enough of an interest.
Yes.
Anyway, and then his second argument, you've very accurately summarised.
Can I deal with the first argument first?
Any order you like, yes. Yes.
If we look at Nyazi,
Yes.
we get in the judgment of Lord Justice Jacob the clearest indication. It's at page 878.
Thank you.
Behind tab 20.
Yes.
But for present purposes, if I can invite your lordships to paragraph 14 on page 883.
Thank you.
Because the question of what amounted to an estate or interest was considered.
Yes.
And there were three. The Court of Appeal identified three possibilities.
Yeah, well, nobody's going for the first, I take it.
The commercial interest, which the court said they had no hesitation in rejecting, some sort of legally recognised right, particularly a covenant or easement, or both, must be vested in the landlord. And then there was also meaning 3, which was canvassed by the tenant, an installation including the defective portion, wherever it is in the building, provided the landlord has an estate or interest in that installation itself, considered as itself part of the building. And dealing with meaning 3, which was proposed at paragraph H, Lord Justice Jacob said, meaning 3 would make Nyazi liable because it has an interest in the pipework and electricity supply by way of covenant from the head landlord or easement or both. And so the starting point in our respectful submission is that quite clearly an easement is capable of amounting to an interest in the common parts. The appellant's case, as I understand it, is that for the duration of the short-hold tenancy and as part and parcel of the demise of the premises by Mr. Kumarasamy to Mr. Edwards, the appellant also divested himself, as between him and the respondent, of his shared interest in the common parts, and hence an interest that he had before the tenancy has, as it were, disappeared. That was my understanding of the argument, and that's why I supplied the additional note, because in our respectful submission it is entirely illogical for...
You say once he's got an interest, it remains an interest simply because he sublets the interest. It doesn't stop it being an interest.
Absolutely.
Is that
and it's a shared interest. It's a shared interest that facilitates a number of the rights and obligations assumes that the intermediate landlord in this case has to have, because the obligation to repair necessarily engages or involves a right to enjoy the common parts. If the appellant, for instance, wished to visit his tenant, to knock on his front door and say, your rent's outstanding, then the notion that he would not be able to do that because he has ceased to have any interest and enjoyment in the common parts is, in our respectful submission, one which
Your point is, if it was an interest when granted, A, as a matter of law, it can't cease to be an interest, and
Indeed.
B, as a matter of fact, it still is an interest that he's going to be able to enjoy,
yes,
as a matter of fact.
Indeed. And that's the short point on that.
But so far as the first point is concerned, I mean, Lord Justice Jacob is dealing with having an estate or interest in the installation in 11.1a(b), whereas we're concerned with an interest in any part of the building in 11.1a(a).
Yes. And that's important because Section 11 distinguishes between any part of the building in which the lessor has an estate or interest.
I mean, if I've got a right to hot water from a hot water tank, I haven't got an interest in the hot water tank, but if I've got a right of way over a hallway, you say I do have an interest in the
Indeed.
hallway. Yes, sir.
Niazi, of course, was an installations case, and
Yes, it was.
we-
We see from the question which Lord Justice Jacob poses in paragraph 14.
and Section 11.1a (b), which deals with installations,
Yep.
includes a reference to an installation which directly or indirectly serves the dwelling house and which either one forms part of any building, forms part of any part of a building which the lessor has an estate or interest, or is owned by the lessor or under his control. And so we submit that estate or interest, the legislature could have said any part of the building which the lessor in which is owned by the lessor or is under his control in 1a(a), but it didn't. And estate or interest therefore envisages some lesser interest than ownership or control.
But wasn't the landlord's easement here incidental to the occupation and enjoyment of the flat? Well, while the subtenancy is in existence, he has no rights to the occupation or enjoyment of the flat. So what's left of his easement?
Well, we submit it's incidental to, but it's not extinguished because he is no longer in occupation of the flat. It's a shared right, and it is.
You say he can use it to go to the flat for anything connected with the subtenant's use of the flat, and in connection with his projected use of the flat when the subtenant goes.
Indeed.
But I mean, the example that you give of going off to remind the tenant that his rent is in arrears, that's not an exercise of any right under the lease. It's the same rights that he would have if he was the grocer, whose bill hadn't been paid. You have an implied right to go and knock at the door of a flat when going about any lawful business. It's part of the tenant's right over the common parts that people who wish to visit him can go there.
Mm-hmm. Well, I think what I was seeking to do was to illustrate that on my learned friend's analysis, the appellant, if he has divested himself of the right to enjoy the common parts at all, is, barring one or two possible exceptions, is a trespasser so far as the premises are concerned, and that we say it doesn't go that far. It can't go that far because of the obligations that continue following the demise, not least the obligation to keep the structure and exterior of the premises in repair.
Although
so they have to be used.
Although the subtenant has been granted the easement, he couldn't say to the tenant, "You can't come to the flat. I forbid you to use the easement." to come to the flat.
Exactly, if I may, yeah.
It's a pretty bare right, though. But it, nonetheless, you say, is still a right.
If, as we suggest, Section 11 envisages that there will be defects in the common parts which will fall within the ambit of the landlord's obligation to repair, then it follows that there must be some estate or interest. And if it's not ownership or control, and if my learned friend says an easement is not sufficient in these circumstances, then we ask rhetorically, what on earth is it? And it not only logical, it makes sense for an easement over the common parts to fall fairly and squarely within the ambit of an interest, if not an estate. And the notion that it is dispensed with on the demise of the flat is one, first of all, for which there is, as we in our researches find no authority, and secondly, for the reasons I've dealt with, or we've dealt with in the additional note.
Well, there's no authority either way, is there?
I'm sorry, my lord?
There's no authority in your favour either,
Well, no.
any more than against you. No. Okay.
Can I just then deal with a linked matter, and that relates to the question of whether the true exception to the rule looks to when notice is required. The general rule, obviously, is that notice is not required. So,
Well, the general rule relating to repairing covenants.
Indeed,
Yes,
I'm sorry.
that's
So
right.
the true exception to the rule looks to when notice is required,
Yes.
not the other way around. And there may be a difference there. There may be a distinction. One can extrapolate from the fact of when notice is required as to when notice is not required. But the thrust of the cases, both before and after this legislation was enacted, do not actually focus on the questions of possession and control. They look to, in our respectful submission, the issue of whether or not the exclusivity of possession and control which is given to the tenant, so far as the demised premises are concerned, gives the tenant a knowledge which the landlord does not have and cannot acquire. And that is the cardinal distinction in our respectful submission.
And this is really why you refer us to the Law Commission's report, is it?
Indeed.
Paragraph 211 and 212 in particular.
Yes.
Yes, I see.
And
They
if,
deal with the position of subtenants.
I'm sorry,
Does that deal with the position of blocks of flats?
No, it simply says the exception to the rule, i.e. the requirement for notice, is based on the fact that the tenant is in possession and he knows. But it doesn't deal specifically with subtenancies or blocks of flats. But it's Lord Justice North's explanation of the principle.
but I don't want to, your lordships are familiar with the authorities now, but the hallmark of the rationale is the question of whether or not the disrepair is inside, within, or in the demised premises.
That's what Lord Justice North says, but that is one possible explanation. The other possible explanation is that it applies to any case where the property concerned is not in the landlord's possession or control.
Yes.
Lord Justice North is plainly in your favour on this,
Well,
but it's ultimately obiter, isn't it? Because it's not necessary for the decision in that case.
It isn't in our respectful submission. And whereas one can, if we look through the cases, pick up on that expression, possession and control, as being the determining feature which governs whether or not notice is or is not given. In our respectful submission, the foundation for all those cases is whether or not it is the tenant who has the knowledge and ability to know of the disrepair, in contradistinction to the landlord who doesn't have that ability to acquire that knowledge. I'm just pausing there for one moment, if I may say, just while it's on my mind. 11.3a which I'll come to if I may in due course.
Of course.
11.3a is not dependent on notice by the tenant. That isn't an expression that appears in 3a, and 3a cannot be read so as to include such an expression. All 3a does, it's axiomatic from 3a that the landlord has knowledge, because otherwise he wouldn't appreciate that he needs to carry out the works or repairs. That knowledge can come from any source. It could come from the tenant, obviously, if notice is given. It could come from the landlord on routine inspection and maintenance. It could come from any source. That is, so the notion that 11.3a can only be read by assuming that the tenant has given notice is, in our respectful submission, flawed. But that was a side issue.
The point I was really putting to you is that why should we apply any of these authorities to this present situation, a block of flats, where one of the tenants is sublet? I mean, the common sense of the matter is the person who's should be repairing is the head landlord who has control. The intermediate landlord has no reason to be there or to know anything about it. And so surely the common sense is that there should be some sort of ground of notice to him so that he can then notify the head landlord. But I don't see why any of these cases really help us in dealing with this situation, which is quite different.
An intermediate landlord, whether he's an intermediate landlord or the head landlord, if it is a tenancy to which Section 11 applies, has the obligations which follow from that status.
Yes, of course. And I mean, I take your point on 3A. That can work either way. It's sort of neutral, I think, on this. But simply if one's asking what is the appropriate sort of test to apply, then surely it makes quite a lot of sense to say because the intermediate tenant doesn't have any possession or control or any reason to know what's going on, it's common sense he should be given notice.
It occurred to me during the course of the argument that if the intermediate landlord doesn't have possession or control and notice is required, what is the situation in relation to a tenant so far as his interest in the common parts are concerned? Because he doesn't have possession, interest or control.
No, but he's
using
them. He can see something's not in repair, so he notifies his immediate landlord.
Well, he may not. And he would say, well, I don't have possession, interest or control, and therefore there's no reason why I should give notice. And in that situation where you have that argument, landlord saying, well, I don't have possession or control, so I need notice. The tenant saying, I don't have possession or control, I don't need to give notice. The default position must be, because it's the general rule in the section, that notice is required. I've touched upon in the additional points that we make why it is, and I'm looking at paragraph 4, if I may, at page 1038. Why it is that the burden of repair of the structure and exterior of the dwelling house or a part of the building is as it is. And the important point in our respectful submission is if the respondent is correct that the true rationale for the exception to the rule is that it is the tenant who has the knowledge and the means to get the knowledge, whereas the landlord does not, then the landlord can acquire knowledge through his continuing shared right in the common parts and his obligation to keep in repair the structure and exterior by engaging in a system of inspection and maintenance, appointing an agent to do so if as appears to be the case, in the case, the appellant is some distance away from the property that he owns. And for that reason, in our respectful submission, there is absolutely no justification for departing, making any further exception from the general rule that notice is not required, because it is necessary to imply a requirement of notice where the landlord has the means to acquire the knowledge. And that is, in our respectful submission, the touchstone for the exception to the general rule.
How does that apply in relation to defects which wouldn't, which emerge between what might be the frequency of reasonable inspections? I mean, obviously you could get a defect of some kind appearing in the premises, a disrepair, which, I mean, unless you're giving repair a particular meaning, but some defect requiring repair, which may suddenly appear one morning.
Yes.
Perhaps a result of an accident of some kind.
Yes. Well, in that case, the landlord's responsibility, the landlord's obligation, and breach of covenant arises as soon as the defect happens.
Yeah. So in fact, he can't protect himself completely by instituting a reasonable system of inspection.
No, he can't, my lord. But as I suggest, this legislation seeks to achieve a balance between the landlord and the tenant. And generally speaking, as I suggest in paragraph 4, the burden on the landlord is to keep the structure and exterior, drains, external pipes, and so on in repair. Those are likely to be disrepair caused by neglect and failure to maintain, and are more likely to be the more expensive elements. And so it was envisaged it was designed that the landlord would have that greater responsibility. And if it's the case that a defect appears during an inspection, as your lordship has given an example,
After.
well, that is, if I can put it this way, one of those things. The general rule applies.
I mean, your point would be that whoever's liable for repairs, and whether it's on notice or not, there's always a risk of something happening catastrophically or suddenly.
Yes. And
it's allocation of risk. And you say, looking at the statute, the allocation of risk in relation to the sort of problem that arose in this case, it places it firmly on the landlord under the relevant lease.
Yes. And there is every good policy reason as to why that should be the case.
Well,
the only exception to the only additional exception was one which Lord Justice Norse posed in the British Telecommunications case, where he suggested that if the defect arose as a result of an occurrence entirely out with the landlord's control, then that might be a situation in which the landlord could not be in breach of his covenant. But Lord Justice Norse left that open, and it's not a matter that arises for, in our respectful submission, for determination.
if you go back to the old cases, including Murphy and the cases cited in Murphy and Hurley, and the McCarrick case, and what Lord Justice Atkins said in Morgan and the earlier cases, they all make the point that if it's premises which the tenant is in possession of, it's inappropriate because the landlord is out of possession and therefore can't know. The tenant's in possession and therefore can know. But what none of them deal with is a case where the landlord's out of possession but the tenant isn't in possession either, like the common parts. Now, Lord Justice Norse is the only person who says anything about that, but he hasn't really considered, he's not really addressing himself to this case, which applies here, where neither the landlord under the sublease nor the tenant under the sublease is in possession or control.
That's why I suggest, if one looks at why Section 11 was enacted in that way, the default position, if I can call it that, must be that the landlord.
It begs the question, it doesn't deal with notice, other than in 11.3a. Yeah, okay. Thank you.
I wonder whether I ought to assist by identifying just briefly the authorities which, in our respectful submission, deal with the question of or establish.
Yes.
The critical criteria here is whether the landlord has the knowledge and the means of acquiring the knowledge of the relevant defect. And that is the true, that justifies...
You say that's the issue on the notice point?
It
okay,
is.
Thank you.
And if I can start, please, and I'll deal with this very briefly because I know your lordships are familiar. At tab 13, which is the in the authorities,
Macon and Watkinson.
This is Macon and Watkinson.
Yeah.
At page 765 in the
Yes.
authorities bundle, Baron Bramwell, Baron Channel, second paragraph down. Now here repairs are to be done to the exterior of the premises, as to which it is just possible that the lessor might by observation acquire a knowledge of their necessity, but the main timbers of the building which must be within its carcass and the roofs are to be kept in repair, and of the repairs required for these he could have no knowledge without notice. He could not enter to see the condition of these parts, even though independent of his obligation under covenant, it might be of great consequence to him to be acquainted with it. And
That suggests that if the landlord isn't in possession, that's the test, not whether the tenant's in possession. Doesn't it? Read on its own. Anyway, yep, thank you.
If we look to, please, Baron Bramwell at page 767, top of the page, if we look to the reason of the rule, it is that when a thing is in the knowledge of the plaintiff but cannot be in the knowledge of the defendant, but the defendant can only guess or speculate about the matter, then notice is necessary.
That then suggests that it's in the possession of the tenant.
Yes.
Yes, okay, thank you.
If perhaps I can ask you to go to tab 1, the Bishop and Consolidated London Properties case.
Yes.
This is a judgment of Mr. Justice Dupart.
Yes.
And at page 580,
Yep.
Unfortunately, the photocopying isn't very good, but if I can invite you to left-hand side, the last paragraph beginning, that being the law.
Yes.
A little further down, he was bound by his covenant to have the main walls in repair at all times during the term, because in the case of the letting of an ordinary house, the lessor would not normally have any knowledge of the existence of defects in the main walls. The tenant has access to the premises and, apart from the covenant, can exclude the lessor from the premises, therefore knows of the defects, and must be expected to have the earliest possible notice of them, the lessor being in a different position.
Yes.
And then at tab 28, Treadway and Machin, which I needn't actually take you to because the ratio is referred to at some length in the judgment of Mr. Justice Salter in Mells against Home, tab 17. If I can invite you to that. Case we've already looked at, 824. In some cases, no doubt, this is the middle of the page, there must be read into a covenant by a landlord to repair a condition that the tenant must give him notice of the want of repair before he can be entitled to complain of it. The principle of that rule is thus laid down by Bramwell, Macon and Watkinson. When a thing is in the knowledge of the plaintiff but cannot be in the knowledge of the defendant, but the defendant can only guess or speculate about the matter, then notice is necessary. This was also put very clearly by Master of Rolls Collins and Treadway Machin, that rule rests upon the principle that the landlord is not the occupier of the premises and has no means of knowing what is the condition of the premises unless he is told, because he has no right of access to the devised premises, whereas the occupier has the best means of knowing of any want of repair. To justify the court in reading into a covenant a condition which is not there must be very strong grounds for doing so. Here there are no such grounds. The roof was in possession and control of the defendants, not of the plaintiffs. Therefore, there is no justification for saying that they cannot enforce the covenant in the absence of notice. And then O'Brien and Robinson, the court is familiar with, and then finally, to complete these cases which demonstrate the proposition which I seek to make, the British Telecom case, Lord Justice Norse, it's behind divider tab 2. And at page 589, letter G, it is now established by a line of authority, culminating in the decision of the House of Lords in O'Brien and Robinson, where a defect occurs in the demised premises themselves, a landlord is in breach of his obligation to keep them in repair only when he has information about the existence of the defect, such as would put a reasonable landlord on inquiry as to whether works of repair to it are needed, and he has failed to carry out the necessary works with reasonable expedition thereafter.
It wasn't even a case about notice, was it? Wasn't it accepted between A and B on 590 that the landlords did have notice? They were asking for, as it were, a collateral facility,
Yes.
Namely reasonable time to get their act
Yes,
together.
exactly. Indeed. Indeed. I mention it only because Lord Justice Norse referred to what he described as the rule in O'Brien and Robinson and the case of Macon and Watkinson. And there was no suggestion, although it might not have been strictly necessary to have determined it, that the exception to the rule was one, the rationale for which was that a landlord does not have the knowledge and cannot obtain that knowledge. And pausing there, all the cases make it clear that the fact that the landlord has a right on notice to inspect doesn't detract from the proposition that he doesn't have the ability to obtain the knowledge which the tenant has. And that is, in our respectful submission, the most important foundation stone for the distinction between the situation where notice is required and the situation when it is not. It is right to point out, as my learned friend has, that a number of the authorities refer to the distinction between the situation where the landlord remains in possession and control. And the argument, as I understand it to be, is that if there were a right to repair, as Lord Justice Lewison suggested there would be, with that right, a degree of control.
But if that's right, then why do you ever imply a notice? Because the combination of section 11.1 and 11.6 means that the landlord has the right to come in whenever he wants to look at the premises, and the right to carry out repairs, indeed the duty to carry out repairs if he sees them. So why is there ever a need for notice if your argument...
I'm sorry.
Why is there ever a need for notice if your argument's right? The landlord has a right to repair the easement, says Lord Justice Lewison. That's good enough. But the landlord has the right to repair the whole premises. Indeed, he's got the duty to repair the premises and the right to inspect under section 11.6. So if Lord Justice Lewis is right, it might be said that O'Brien and Robinson's wrong.
Well, although I don't, as it were, relinquish the point that there is a right to repair on the part of the intermediate landlord. Lord
That's
Justice
another point.
Lewison, I would entirely accept my learned friend's criticism with respect to Lord Justice Lewison, in the sense that the reference to the right to repair, the ancillary right, the ancillary easement, and the right to repair was described in a fairly sweeping way, without some of the authorities that my learned friend has referred to, which would suggest that the right to repair is not a necessary, it is not an inevitable incident of the right of way, but is only one which occurs where it's reasonably necessary for it to exist. In our respectful submission, the right to repair that Lord Justice Lewison mentioned is entirely immaterial to the conclusion that he reached. He dealt with it because it had been raised in front of the judge at first on the appeal, Judge May, QC, and he, in a short paragraph, just pointed out that it was a shame that the judge's attention had not been drawn to the fact that an easement, an easement over the common parts, where there was an express grant of an easement, the grant will carry with it an ancillary right on the part of the dominant owner to carry out repairs on the servant owner's land. Well, whether that's strictly right or not, in our respectful submission, is immaterial for the purposes of the matters that your lordship is considering, because our case is, even if there is no right to repair, there is an obligation to repair, which is a necessary feature of Section 11. Just because you don't have a right to repair doesn't mean to say that your obligation to do so under Section 11 is anyway removed or diluted. And in fact, if the situation is that there is an obligation to repair but not a right, then that brings into play Section 11.3a, because Section 11.3a envisages that there isn't a sufficient right on the part of the landlord to undertake the repairs, which he is obliged to do, because the covenant, to put it, as my learned friend put it, the covenant has bitten.
Will you presumably say that even if Mr. Rainey is right, adopting Mr. Justice Atherton's approach, as soon as the disrepair occurred, you should have, the appellant should have notified the freeholder, and if the freeholder hadn't dealt with it, the appellant should have dealt with it under the last resort principle, which Mr. Justice Atherton accepted. Therefore, there was a right to repair, albeit it was not quite as simple as Lord Justice Lewison suggested.
Well, our position is that there is in fact here a right to repair. It's a right to repair that is a reasonably necessary incident.
Yes, I was being put to you, assume that's not right.
Oh, I'm sorry, I beg your pardon.
Yes, and then what then? The duty is to notify the head landlord and get the necessary right. But the trouble with that is the head landlord is entitled to say, well, I'm not going to grant it to you because I'm going to do the repairs and you only have a last resort right. Well, how does that work?
But I have acknowledged that if my learned friend is right, and there was no right to repair, and Lord Justice Lewison is wrong about that, it doesn't affect the fact that if the covenant bites,
I understand that. What I'm trying to understand is how 3A works in a situation where you have a block of flats where the primary obligation is in the head landlord or the managing company. It's pretty odd for you to be going to the head landlord saying, for the intermediate landlord to be going to the head landlord and say, well, I want the right to repair, when the head landlord says, well, it's my job to do that and I'm going to get on and do it. So the only right you have is a last resort right under the principle. And you say that's enough, is it? I mean, that brings it to play, yeah.
You say that your landlord's last resort right is enough to impose the liability on him.
Oh, yes, you are.
Yeah. Yes, that's right. Yes?
The paved area issue. Well, my learned friend is correct when he anticipated, I would say, that it was a finding by the district judge.
He says that even if that's right, the district judge misdirected himself as a matter of law, because the right question was that posed by Lord Justice Lewison in his judgment, although he says Lord Justice Lewison gave the wrong answer. But he says the right question was that put by Lord Justice Lewison, namely in page 382, can the paved area which leads from the front door to the car park be described as part of the exterior of the front hall? Whereas he says the district judge posed the wrong question.
Yes, he did. But
Do you accept that?
I do.
Right.
It was accepted before Judge May, and I don't depart from that. But the importance is that the district judge made a number of findings of fact. He may have applied the wrong law, but there's findings of fact in our respectful submission, ones which he was entitled to make, and the Court of Appeal accepted. And the findings were that this was a short stretch of paved area immediately in front of the front door, leading from the hallway, and leading to the common parts, in particular the car park and the bin store. And as such, it formed an essential means of access from the common parts to the front door and into the hallway itself. And in our respectful submission, these are matters of fact and degree. And once the finding that was made that the common parts included the hallway, in respect of which the appellant had an interest by the easement, then there's nothing perverse or indeed unreasonable about saying or about concluding that that area of pavement, effectively an extension of the hallway to the common parts, was or formed part of the exterior of the part of the building over which or in which the appellant had an estate or interest. And the case of Brown, which the Court of Appeal referred to, these are always fact-specific in our respect.
What does the exterior of the mean? I mean, you've got to start by asking yourself what that means. It's not the curtilage, it's the exterior of the part of the building. So
yes,
is that not referring to the physical component of the building or the part of the building itself rather than something separate?
Well, it could, but not necessarily so.
I mean, if one looks at the picture on page 243 and sees where he says he was injured, I mean, how far does it go if that concrete, that paved area had extended along the whole of the front towards the binned area? Would that all have been part of the exterior of the building?
Well, in our respectful submission, yes, and it was a conclusion that Lord Justice Lewison was entitled to.
Well, wait a minute. I think you've accepted that the correct question is it part of the exterior of the front hall, not it part of the exterior of the building?
Because the pavement itself cannot be part of the building, but is it part of the is it the exterior of a part of the building in which the appellant had an estate or interest? If he had an estate or interest in the hallway immediately behind that front door, then it is entirely logical that this paved area, which is in effect an extension of that thoroughfare from the common parts into the hallway, form part of the exterior of that part of the building in which the appellant had an estate or interest.
I mean, the district judge, I'm sorry to have interrupted you, the district judge was finding that the paved area was part of the exterior of this second floor flat.
Yes.
Yes.
I mean, and he took rather an extravagant view in that regard. So it's quite difficult for you to lift out of that analysis something that helps deal with the correct and focused question. Is it part of the exterior of the front hall? I mean, would you say it was the paved area was part of the exterior of the back hall and the stairs up to the first floor? Where does it all end, Mr. Benson?
It is left, in our respectful submission, to the tribunal of fact to reach a common sense view, which in our respectful submission the Court of Appeal did, as to whether or not a particular feature forms part of the exterior of a part of the building.
And you say that the first time the proper question was asked was, either you say the district judge reached the decision he was entitled to reach, or you say the first time the proper question was asked was in the Court of Appeal and they reached a conclusion they were entitled to reach. Is that
yes,
right? Is that convenient? Do you want to say something? Sorry.
Well, in fairness to the Deputy District Judge,
Yes.
If I can just...
Yes. You want to deal with this after the adjournment?
Yes, if I may.
Yes, you may.
I
That would be fine.
Very much longer.
No, that's fine. Thank you very much indeed. We'll resume again at 2 o'clock. Thank you very much. Court's now adjourned.